Election has become a cardinal basis for democracy, and if election will deliver on its promises of producing the right kind of leadership which the people desire, even though I must say sometimes that the people can get emotional, and sometimes because of the dynamics of society can actually go for populism, like the mayor of Entebbe referred to, instead of substance. It happens. But by and large, I believe that the people know what is good for them, and they know who therefore encapsulates what is good for them. And we must therefore develop rules that are simple, that are clear, and the process must be transparent. And I dare say that our electoral process in Nigeria is far from simple, is far from clear, and the process is also far from being transparent. It takes a lot of guts, it takes a lot of ingenuity, it takes what you may want to call a bit of luck to put all the ingredients together to win an election. Election involves a combination of factors: the voters, the empire, the security functionaries, the judiciary, and of course, the legal profession. Nigeria, as the largest democracy in Africa by virtue of our population, has made significant progress in consolidating democratic institutions since the transition from military rule to civilian governance in 1999, which we fondly refer to as the Fourth Republic. You recall that our First Republic was truncated by military intervention. The Second Republic was nurtured by the military and killed by the military. The Third Republic itself was very much short-lived, and the Fourth Republic is what we have today. At least, if we have nothing to celebrate at all, as imperfect as our system is, that we've been able to have a change of button from civilian to civilian 4 times now. 4 times, am I correct? From Obasanjo to Yaradua to Goodluck to Buhari, this is the 5th time. At least we know that there have been a lot of questions that are still unanswered in some of the processes by which successors emerged, but at least that we have been able to sustain civilian rule, I think is something to clap for ourselves. I do not believe in throwing out the baby and the bathwater, because military rule, as is becoming the fashion in Africa, in West Africa, that due to the failure of governance and leadership, that military rule is beginning to be attractive again. I want us to know that the leopard does not change its skin. Military rule will never be inclusive, will never be democratic, and it's a government of a few people, by a few people, and in fact, a lot of the times, for the few people. We cannot afford to return to those days of military rule. And I'm worried by the agitations by some people, not because I'm a politician in office, but I do not think that it will help us. Some of the distortions in our society today, some of the institutional malfunctions today in Nigeria were because those institutions were nurtured under military rule. And it's difficult to reverse some of them. Today, people talk about a defective constitution. It was given to us by military fiat. It will interest you to note that by the time the elections held in 1999, Chief Falana will confirm, we did not even have a clean copy of the Constitution. So we didn't know what the rules were. We began to stumble on them gradually. This is the unpredictability that military rule brings. And I think no matter the frustrations we have with government and with governance, we must not return to our vomit. To strengthen democracy and enhance citizen participation, electoral and judicial reforms are indispensable. There is urgent need for electoral and judicial reforms in Nigeria, as its benefits are invaluable. It will serve to ensure fairer, more inclusive, transparent elections, and the resolution of conflicts that follow after the declaration of results. The judiciary plays a crucial role in the electoral process. It does this by upholding the integrity of the Constitution and extant electoral laws, protecting the rights of political parties and their candidates, and ensuring justice for voters. In recent times, however, the judiciary has been plagued by numerous challenges that have called to question the effectiveness, integrity of the judiciary, and consequently the trust the public has placed on it. It is in this vein that comprehensive judicial reforms become expedient to promote a fair, efficient, and judicial system. The benefits of such an important exercise and this critical stage of our nation's development can be better imagined. Now, since 1999, every election cycle has had new legal regimes, in most cases hurriedly put together to address the problems that sprouted in the preceding elections. It is thus interesting that laws are still in a state of flux and justifiable change, with the concomitant effect of the complications inherent in the model and jumble of its implementation by the electoral body, political parties, and other electoral stakeholders. These have been further exacerbated by the varying conflicting judgments and orders by the tribunals and courts in the course of the resolution of electoral reforms. The plethora of conflicting judgments delivered in recent times are testaments that have left gaping holes in the entire gamut of the country's democracy. In the gamut of the country's democracy, in the governance process, and in the leadership recruitment process. For the judiciary, there is an urgent need to safeguard its independence and integrity. What we noticed in recent past is partisan interference, invasion and meddlesome interloping of tribunals and courts by politicians and their cronies. This has become very worrisome. Enhancing accountability and the protection of the doctrine of stare decisis, that is judicial precedence, will serve to promote the revered ethics of the bench and in the long run, reduce corruption, bribery, fraud, and nepotism. Let me say this, that the judgments that came out of the 2023 elections particularly were such that even renowned professors of law became confused as to what is our jurisprudence. Settled principles of law became contentious. And I was in the Supreme Court the day my own judgment was delivered, and that day at least 8 judgments were delivered. And I sat through them. And to my amazement, there was no single new principle of law enunciated. All the judgments were a restatement and a reaffirmation of the basic principles of law. No wonder one of the Supreme Court justices said, both the legal profession and the judiciary must up their game, because if there is any particular segment of society that has added to the confusion and lack of credibility in our electoral system, it is the lawyers and the judiciary. Time has come when lawyers of integrity must tell their clients to your face, you have a bad case. I'm not going to take this matter. But like we say in Nigeria, lawyers must chop. And so when elections have been contested, won and lost, you are put through a grilling process that is expensive. I call it some bit of emotional terror politics of law, and will be able to bring this issue to the front border of national discourse. If Haskell Foundation succeeds in bringing us to the round table to discuss the future of our electoral process and the reforms that we need to carry, I think you would have fulfilled your mandate. Now, one of the most important things to my mind is to have a second look again at the electoral laws themselves. The laws provide the framework for electoral administration, party registration and administration, constituency delimitation and delineation, voter registration, campaigning, accreditation, voting, collection of results, use of appropriate technology, management and conduct of elections, and the dispute resolution mechanism. Now, the first challenge we have, you know, many of you are not satisfied with the delineation of even polling units in the country. This is where injustice begins, and a lot of injustice has been done in the process of delineating constituencies. I hope that we can have the bravery to be able to discuss this and find a way of amicably resolving this. But even after that, even with the present situation as it is, party politics, party administration is something that is yet to be fully organized. I believe that one of the best organized political parties in Nigeria's history was the UPN, the Unity Party of Nigeria, by Chief Awolowo in the Second Republic. It was a party that was well organized, well disciplined, with a lot of intellectual content, and we need to learn from such organizations. Today, even the parties and their rules are not well defined. And you find that a lot of the times, the choice of candidates is very undemocratic, is left to the whims and caprices of the cabal that decide who should win. These are things we need to look into. We need the political will to decide and insist that some of the proposals we have in our extant laws, for example, under the 2022 Electoral Act, it is very clear that technology was intended to drive that election. Did we succeed? To what extent did we succeed? These are questions we need to ask. And how do we make the system better so that we can have fairer outcomes? There are reforms that should be anchored on the need to address apparent and perceived deficiencies and weaknesses in the process. While this will uphold democratic principles and values, it will serve to improve public confidence in the electoral process. I need not bore you with certain details. Now, while proposals and propositions abound in academic literature and legislative hearings on the way forward, for me it is only expedient, prudent, and indeed convenient to look at electoral and judicial reforms through the prism of my immediate experience under what may be termed as the Plateau debacle. It is no longer news that recent happenings from Plateau State have thrown up hitherto overlooked aspects of Nigeria's electoral jurisprudence that require urgent attention. The state was in the news for many wrong reasons because of the protracted judicial imbroglio that we were plunged into due to a number of avoidable lapses. In Plateau State particularly, I earlier referred to the issue, one of the first issues that came to the fore was who governs the domestic issues and internal affairs of political parties. Should the judiciary be the one to meddle into the domestic affairs of political parties when it is a voluntary association that people come into? You come in freely, you exit freely. Therefore, the only time that the court should be able to come into it is when you are not keeping in tandem with the rules that you have set for yourselves. And that is why it has been traditionally held that the court should be wary of interfering in the domestic affairs of political parties. But what we saw in 2023 is that not only were members of the political party are concerned about happenings in their party, that interlopers who were not members of that party were allowed by the courts to have a say in the happenings of another political party. These are the doors we need to shut. People should be mindful of what happens in their own compound. They should not be allowed to piddling disputes among political parties is something that would need to be spoken into. Now, this is about essentially the role of the judiciary. The judiciary itself thrives on what we call the principle of judicial precedent. In another interpretation of it is called judicial discipline, which relates to the hierarchy of courts. It is worrisome that where the Supreme Court, which is the Supreme Court of the land, the final court of the land, has made a pronouncement that lower courts reverse what the Supreme Court has stated, and there are no sanctions. I think we need to look into this. We must restore judicial discipline, and what has happened on the Plateau particularly is that where it is found that a lower court or tribunal brazenly overturned the judgment of the Supreme Court, not only should there be sanctions for those who did it, but I believe that that particular judgment should be considered a travesty. We must have the boldness to insist that the right things be done. Let me quickly rush through. I would be done in a little while. We are also noting a very interesting development due to one of the fallouts of the 2023 electoral process is that the electoral umpire decides to interpret the law against what is the plain language of even the electoral law and the judiciary itself. I give you a typical example. Where a court nullified an election and ordered that all parties shall participate in the rerun. And I use that phrase deliberately. All parties. And excuse me, I don't think we need to go back to school to learn English. Except if it is interpreted otherwise in Entebbe. But I think that all parties means all. Even if it was a mistake, the court stated so in writing. I do not think it gives room for INEC to decide to interpret the meaning of all, which is to exclude a party they desire to exclude. And therefore, INEC itself must be made to obey the extant laws and to ensure that they do not give an interpretation of their own. One of the challenges, again, is that in several instances, when you suffer injustice, the time and the procedure to remedy it becomes a problem. And therefore, I believe that the Supreme Court must summon the courage to exploit its inherent jurisdiction to do justice, where there is a lacuna in our body of laws, that the Supreme Court, as a court of policy, must rise to the occasion and do justice that is apparent in every case. There are many issues we need to look into. The issues of corruption in the electoral process. These are things I cannot have the luxury of time to talk about in this keynote address. But many of us who are living witnesses in Nigeria know that the process is far from being transparent. From the process by which people get elected into party offices, to the process by which primaries are conducted, to the process by which the electoral body itself manages the process. One thing is very clear, that a lot of the times, if the key candidates and parties in an election do not bring out money to manage the process will not go smoothly. And of course, in the process, there will be clashes. There will be show of strength of who has more money to influence. And these are things we must discourage. Then, of course, even the issue of protracted litigations. The 2022 Electoral Act try to make an attempt to ensure that as much as possible litigations are done with, given the length of time between emergence of candidates and elections themselves, that there will be sufficient time to deal with a lot of the issues. Where you have 8 months between primaries and elections, and yet pre-election matters are still being brought up after the election, I think this is a problem that is created that we need to address. Now, what does this tell us? That there's an intricate connection between the judicial process and the integrity of the electoral process. Because it is the judicial process that is designed to safeguard the integrity of the electoral process. Therefore, apart from the politicians, apart from INEC, 2 critical persons that are important to electoral success in Nigeria are the judiciary and the legal profession. I, in all honesty, must tell you that from experience, I know that if we must get it right, the legal profession needs to wake up. If we must get it right, the legal profession needs to wake up. And I don't need to elaborate more on this. I know that many senior lawyers will confirm what I'm saying, because we are the people that advise litigants to sabotage the system. We are the people that advise, sometimes we are the people that go out of our way to also assure litigants that we can influence the judicial process to their favor, even when we know it is wrong. I pray that senior members of the bar, like Chief Falana, will rise to the occasion and speak truth to ourselves that we need to wake up. We need to wake up. I think the last cycle of litigations put our people through so much stress. I tell you, in Plateau State, and I'm not kidding, we recorded at least 4 deaths due to one of the judgments from the Court of Appeal. It was, when elections are won, you will know. Is it not so? When elections are won, you will know. Why then must we controvert an election that has been won and lost? The time has come when we must exalt the rights of voters over technicalities of law. We must ensure that justice is not only done, but is seen to be done. And the ordinary man that will test whether justice has been done is the ordinary voter, not those of us that are the elite and the money bags. I want to challenge this discussion panel to take this discussion further and put it in the front burner of national discourse, that we will start early the process of reform before 2027, because very soon we will know that time has gone. Let's not be taken by surprise like the 2022 Electoral Act, that the president woke up to discover that he had even been excluded from voting in his own party primary. The National Assembly members who passed the law did not know that they had scored an own goal. And so many of them went to party primaries and they were no longer delegates. How did it happen? We must not allow that to happen again. Distinguished ladies and gentlemen, I thank Haske Foundation for giving me the
of the Nigerian Christian Corpus Fellowship. Distinguished guests, ladies and gentlemen, he's been able to